are a lot of elements to this debate, and it's one that will be had over the coming weeks before Parliament returns and the government seeks to repeal these medevac laws altogether. But one of the elements of this debate is what discretion the minister has to reject a transfer when doctors have recommended one, whether they've consulted in person or not. Can the minister say no? Well, according to Christina Keneally, the Shadow Minister for Home Affairs, who we spoke to earlier on the program, the minister does have fairly broad discretion.
Under the medevac legislation and the powers that the minister has, if he determines that somebody is a risk to our national security or public safety, he has the ability to reject them. Also, David, when
but
people...
But this seems to be a fundamental disagreement or misunderstanding of what the law actually says.
David, if you allow me to finish my answer... David, if you would allow me to finish my answer. What the legislation does is it gives the minister that discretion and that power. That is why Labor has supported it.
To be clear on that, the legislation does refer to national security grounds as defined under the ASIO Act. The minister can say no on those grounds. The minister can also say no on criminal grounds. If someone's been convicted of an offence with a jail term of 12 months or more, or sentenced to life in prison, or indeed the death penalty somewhere, well, then they can say no on those grounds as well. Peter Dutton's argument here is that still means people of bad character who don't fit those other requirements can still be brought to Australia. And what's more, he's revealed this afternoon that some already have been.
I think there are some people that have come of bad character, David. I don't think there's any question about that. And under Labor's law... Amongst these 30,
are there any rapists, murderers, paedophiles?
We'll have a look at the details in due course. And I'd make this point, though. The point made by the Labor Party, and you heard a bit of the rhetoric in the previous interview, people of bad character can come, are able to come, and in fact are required to come under Labor's laws that they passed. That's the reality.
Well, the debate this week over whether doctors need to consult the asylum seeker or refugee on Nauru before recommending a transfer, this federal court ruling was in relation to a 29-year-old Iraqi who's been in Nauru for the past 5 years and will now be allowed to come to Australia. This case was brought by the Human Rights Law Centre, and senior lawyer David Burke from the centre joins me now. Look, thanks very much for your time this afternoon. Just explain to me the case itself that we're talking about here. What happened with the efforts to bring this Iraqi man to Australia, and why did this ultimately end up in the federal court?
Well, what happened was that we got two leading doctors to review detailed medical records and information about this man, both of whom said that he was at imminent risk of death. We submitted it under the medevac laws, and the Secretary refused to even give it to the Minister to consider. They took a technical legal argument to effectively delay this man receiving medical care. And that argument was rejected by the federal court, entirely in line with Australian medical standard practice.
Are you able to share, just to the starting point here, in relation to the health condition, why this man was not brought in by the department through its existing system? Why was that rejected, and why did he want to go down this medevac path?
Well, I think that what we have seen is that when the government does not consider itself bound by the medevac laws, we are again back to the point where it is delaying and trying to obstruct people receiving medical care. The fact that we had to file a case in court just to get this man medical treatment really shows how vitally important it is that the medevac laws are in place.
But what sort of condition are we talking about here that meant the department said no to his transfer?
That's really a matter for the department. I think I'm not going to go into the specifics of this man's care, given that we're acting as his lawyers, but I can say that there were two Australian doctors who gave extremely detailed reports about the fact that he was actually at risk of death. You ask why the department didn't transfer him as soon as we told them about that and provided the reports. The simple answer is, I don't know. And that's why we need the medevac laws in place, because they need to be required to allow doctors to make medical decisions rather than politicians and bureaucrats.
There are still, correct me if I'm wrong, more people coming in, though, under the departmental system than under the medevac system. Is that right?
That's right. I think that we've seen about 30 people come through the medevac process and more people come outside of that. And that's also with a lot of those people had legal advocacy and lawyers writing on their behalf to get them transferred over. But it also just shows the fact that when you have the medevac laws in place and it's clear that someone could go through that process, the department responds a lot quicker and gets people appropriate medical care quicker.
So with this court ruling, this federal court ruling, that the doctor the two doctors no longer need to personally engage with the patient in Nauru, at least. How significant is this? Will it see the influx that Peter Dutton talks about of transfers?
I think it's important to note that the medevac laws have not changed. All that this means is that people from Nauru can simply apply for the medevac process. The minister still has the discretion to refuse that application, and there is an independent panel in place that conducts its own assessment of an individual before deciding whether a transfer is necessary. So when we talk about what impact this will have, the reality is that we have had about 30 applications from PNG. The minister has a handful of applications that they now have to consider, but it really just means people who have an extremely obvious need for critical medical care now have to be considered by the minister.
Do you have any numbers on how many the medical panel have actually rejected after two doctors recommended a transfer?
I don't have the exact numbers, but I know that the medical panel has rejected some applications, which I think also just shows that the system is working. The whole idea is that these decisions should be made by an independent panel of experts, which also includes the government's own doctors, and that system is functioning properly.
I guess some look at this and think, well, surely a doctor has to see a patient, either through telemedicine or in person. You don't get a doctor's certificate to take the day off work unless you see the doctor. What do you say to that this makes it easier to recommend a transfer?
Well, I think that the first point is that this is merely an assessment for what treatment the person needs, and it's to allow them to apply for the medevac process. The ultimate decision is not made by these doctors. But the second point is that this is entirely standard medical practice. In hospitals in Australia every day, surgeons and specialists are recommending treatment based on medical records, x-rays, lab results, without ever seeing the patient. I mean, this is high-level specialist care that we're talking about. It's people, it's men and women who are at risk of death and who need appropriate medical care to be provided.
And look, I accept that happens here in Australia, but the difference is we're talking about a decision to actually bring someone into the country who will, in most cases, stay here permanently. That is a different threshold, is it not?
Well, and that is also a decision that is made by the minister. And it's one that if they consider that there is not enough medical evidence, then they can reject it on that grounds, and it goes to an independent panel of expert doctors who conduct their own further assessment of the case. So the reality is the only way someone can be transferred by this process is if either the minister or an independent panel of doctors considers that there is a clear need for treatment. We're talking about a small number of extremely obvious cases where there is an urgent need for care and a risk to somebody's life.
At the end of the day, even before the medevac laws came in, a lot of people have been transferred on medical grounds to Australia. The number the Minister was telling us a little earlier now stands at 1,000 who are here in Australia. That's more than are still remaining on Nauru and Manus Island combined. Do you welcome that? Do you accept that medical transfers are indeed happening perhaps more often than people realise?
I think that the fact that there are 1,000 people who have been transferred really highlights the fact that there is inadequate care on both Nauru and Manus. We are seeing a medical crisis unfolding on the islands. Every day I am speaking to people who are at real risk to life because they simply cannot get the medical care that they need. So I welcome the fact that people are brought to finally receive proper medical treatment. But I think it's also important to note that the government needs to find a solution to the medical and humanitarian crisis that is playing out in offshore detention, and it needs to find a solution extremely quickly.
David Burke, a senior lawyer at the Human Rights Law Centre, thanks very much for joining us this afternoon. Appreciate that.